Hello friends, I hope you are all good. So welcome back to this MCQ video series. So as you know that we have started with the MCQ series wherein you'll get 5 to 7 questions pertaining to securities law, and today's lecture will be the 7th lecture of this video series. This video series will be quite helpful for you for your upcoming SEBI Grade A 2019 examination. As you all know that there has been a news in live wind that SEBI is going to recruit around 100 people each for the coming 3 years. So there is a very high probability that SEBI notification will definitely come this year. So it is high time now that you should start your preparations, and this video series will certainly help you to take a step towards your goal. So before jumping on to the first MCQ of this video series, let me grab this opportunity and let you know about the excellent results produced by EduTap. So for the year 2017, we got 27 final selections in RBI Grade B and 11 final selections in NABARD Grade A. For the next year, that is 2018, our results improved drastically and we got 70 plus final selections in RBI Grade B, 26 final selections in NABARD Grade A. For the same year, that is 2018, with respect to SEBI Grade A examination, we are blessed to have such overwhelming results wherein out of 84 candidates selected, 41 were from EduTap. I would like to take this moment and congratulate all the selected candidates for putting in their hard work and efforts and making it up to the final list. And when it comes to IBPS Agriculture Field Officer, we got 100 plus interview calls. So let's hope that we get a good number of selection in this exam too. For knowing about the courses being offered by EduTap, you can take a quick snapshot of these slides. We offer courses of the mentioned examination, that is RBI Grade B, SEBI Grade A, NABARD Grade A, RBI Assistant and IBPS Agriculture Field Officer. We even offer combo courses for the mentioned combos, that is RBI NABARD SEBI, RBI NABARD, SEBI RBI, NABARD SEBI. So you can opt for any of our combo courses based upon your exam preferences. We are glad to announce that we have launched a new course, that is QRE course for all banking examinations. 3 aspects will be covered with respect to this particular course, that is quantitative aptitude, reasoning ability and English. So wrapping up with the introduction part, and let's move on to the first MCQ of this lecture 7. So moving on to the next slide. So with respect to question number 1, given below are 3 statements related to delisting of securities of a listed company. Which of them is /R correct? So 3 statements are given and we need to identify the correct ones. So as per statement 1, a recognized stock exchange may delist securities on grounds as may be prescribed under the Securities Contract Regulation Act. Okay. As per statement 2, the concerned company may or may not be given a reasonable opportunity of being heard. Okay. As per statement 3, the aggrieved company may file an appeal before SAT within a time span of 45 days. So basically, if you analyze these 3 statements, these are coming up from the listing and delisting part of Securities Contract Regulation Act. So if you have a good understanding with respect to that part, you can easily answer this question, else it would be a little difficult for you. So let's move on to the next slide in order to learn something more about this part. So if you take a close look on section 21A of Securities Contract Regulation Act 1956, this part of Act clearly deals with delisting of securities. As per delisting of securities, a recognized stock exchange may delist the securities after recording the reason thereof from any recognized stock exchange on the grounds as may be prescribed under this Act. So as per this Act, any grounds that may be prescribed under this Act can be a reason because of which a stock exchange can delist a security of a listed company. Moving on to the second point, the securities of the company shall not be delisted unless the company concerned has been given a reasonable opportunity of being heard. So the aggrieved company whose securities are going to be delisted should be given a reasonable opportunity of being heard and a chance to them to defend their case. So moving on with the third point, a listed company or an aggrieved investor may file an appeal before SAT against the decision of recognized stock exchange within a time span of 15 days from the date of the decision of recognized stock exchange delisting the security. So this point basically says that as and when a recognized stock exchange has taken a decision to delist a security, from that day to 15 days from that day, a listed company or an aggrieved investor has an opportunity to file an appeal before SAT if they are unsatisfied with the decision of that stock exchange. Moving on to the fourth point, if SAT is satisfied that the company was prevented by sufficient cause from filing the appeal within the set period, that is of 15 days, it may allow it to file within further period of not exceeding 1 month, which simply says that after 15 days time period from the decision of delisting securities, can an appeal be made to SAT? The answer to this is yes. The only condition is that the Security Appellate Tribunal must be satisfied that the aggrieved company was prevented by a sufficient or a reasonable cause due to which it wasn't able to file an appeal within the prescribed period of 15 days. So that's it with the explanation part. Let's move back to our question number 1 and let's see now we can solve the question or not. So moving on with the statement 1, a recognized stock exchange may delist securities on grounds as may be prescribed under the Securities Contract Regulation Act. This statement is perfectly correct. As per statement 2, the concerned company may or may not be given a reasonable opportunity of being heard. This statement is false because securities of a company cannot be delisted by a recognized stock exchange without giving them a reasonable opportunity of being heard. So this statement is wrong. So moving on with the statement 3, a grieved company, that is the company whose securities are being delisted, may file an appeal before SAT within 45 days. So now we know that this time span is of just 15 days, not 45 days. Hence the statement 3 is wrong. So if we see things in totality, statement 1 is perfectly correct, statement 2 is not correct, statement 3 is also not correct, and we need to identify the correct one. So as per the options, option C becomes our correct answer, which states statement 1 only. So moving on to the next question, that is question number 2. With respect to question number 2, as per Securities Contract Regulation Act 1956, which of the following can accept the application for recognition of stock exchanges? Option A says central government, option B says Securities Exchange Board of India, option C says Reserve Bank of India, option D says both A and B, that is central government and SEBI, option E says A, B, C can accept the application, that is all the three, that is central government, SEBI and RBI can accept the application for recognition of stock exchanges. So I suppose this question is an easy one, and if your basic concepts are clear, then this question will be a cakewalk for you. So let's move on to the next slide and learn something more about this part in the explanation section. So moving on to the next slide. So when we delve into the details of section 3 of Securities Contract Regulation Act 1956, this part purely deals with the application for recognition of stock exchange. So let's move on to the next slide and learn something more about this part. So as per section 3, any stock exchange which is desirous of becoming a recognized stock exchange should make an application in a prescribed manner to the central government, and this power, which is exercisable by central government, has also been delegated to SEBI also. In fact, a lot of power mentioned in the Securities Contract Regulation Act have been delegated to SEBI also, which simply means that most of the powers that are bestowed by this act to the government can be exercised by SEBI also. And accepting an application for recognition of stock exchange is one among such powers. Every recognition application shall be accompanied by a copy of bylaws of stock exchanges which are concerned with regulations and control of contracts, and a copy of rule of stock exchanges. Rules deals with the governing body of stock exchange, its constitution and power in management, and the manner in which the business is to be transacted, the powers and duties of office bearer, and many more things. So if the central government is satisfied that the rules and the bylaws of stock exchanges, which I explained earlier also, are in confirmation or in consonance with the prescribed condition made by the government, then it can grant a recognition. So the basic thing this point is saying is that any application for recognition of stock exchange which is accompanied by a copy of bylaws and the copy of rules, if such rules and bylaws are in confirmation with the conditions prescribed by the government can grant a recognition to the applicant stock exchange. The third point says that rejection to grant recognition must be done only after a proper hearing opportunity has been given to the concerned stock exchange. So basically, you cannot reject an application based upon your whims and fancies. A reasonable opportunity should be given to the concerned stock exchange. Moving on to the last point, once a stock exchange becomes a recognized one, it cannot amend any of its rule without prior approval of central government, which simply means that once a stock exchange has become a recognized one, whenever it has to amend its rule, it needs the prior approval of central government. So that's pretty much it about the explanation part. Let's move back to our question number 2 and let's see now we can solve the question or not. So as per the Securities Contract Regulation Act 1956, which of the following entities can accept the application for recognition of stock exchanges? So basically, as per the Act, central government is the entity which can accept the application, but as this power has been delegated to SEBI also, so both central government as well as SEBI can accept the application for recognition of stock exchanges. So hence, option D becomes our correct answer, which states both A and B. So it's time that we should march to our next question. So moving on to the next slide. As per question number 3, given below are 3 statements related to demutualization. Which of them is /R correct? So 3 statements are given and we need to find out the correct one. As per statement 1, at max 49% of shareholding shall be held by shareholders which have no trading rights. Okay. As per statement 2, the process of demutualization must be completed within a time span of 6 months. Okay. Statement 3 says BSE, that is Bombay Stock Exchange, got demutualized in the year 2007. So basically all these three statements are coming up from the part of corporatization and demutualization of stock exchanges. So let's move on to the next slide to learn something more about this part. So when we delve into the details of Section 4 of Securities Contract Regulation Act 1956, we see that this part purely deals with corporatization and demutualization of stock exchanges. And this question is pertaining to demutualization. So before even learning about demutualization, let's see why was even demutualization needed in the first place. So what happened earlier was that the stock exchanges were broker controlled, which means that the people who had the trading right were also the owner of stock exchanges. Which means that the broker who performed trade on the stock exchange were equally equipped to manage the stock exchanges. So they had the power to tweak the rules and regulation of stock exchanges as per their own convenience, which in a way is totally unethical because they are having unfair advantage with respect to other traders and investors. So in order to curb such practices, demutualization was brought into the action. So now that we know why demutualization was needed in the first place, let's understand the meaning of demutualization in the next slide. So demutualization is just a simple process which separates the ownership and control of stock exchanges from the trading rights of its member, which simply means that if a member of stock exchange has trading rights, then he cannot own or control or manage the stock exchange. On contrary to that, a person who has no trading rights can only own, control and manage the stock exchange. This is the simplest meaning of demutualization, and the process to achieve demutualization, let's discuss further. So in order to achieve demutualization, majority stakes of the stock exchange, that is 51%, have to be given to the investors who do not have the trading rights, which simply means that 51% of the stakes of stock exchanges and the control of stock exchange is held by the investors who do not have the trading rights, that is they cannot trade on that stock exchange. And the other important thing is that if such approval is given, then at least 51% of shareholding within 12 months shall be held by public shareholders who do not have the trading rights. So in order to become demutualized, the concerned stock exchange needs to get this 51% of shareholding held by public shareholders with no trading rights within a time span of 12 months only. So the two most important takeaways from this slide are that 51% of stakes of stock exchanges must be held by the public investors who do not have the trading right. And once the approval is given, then this 51% of shareholding should be held by public shareholders with no trading rights within a time span of 12 months. So moving on to the next slide. In this slide, I'll be discussing some general facts related to two most popular stock exchanges of this country, that is Bombay Stock Exchange and National Stock Exchange. This has nothing to do with Securities Contract Regulation Act. These are general facts which one should know. So Bombay Stock Exchange was founded on 9th July 1875 and it got demutualized on 16th May 2007. It is located in Mumbai, Maharashtra, and BSE Sensex, BSE 500, etc. are its popular indices. And with respect to National Stock Exchange, which is comparatively a newer stock exchange, it was founded in 1992 and it got demutualized in the same year. It is also located in Mumbai, Maharashtra. Nifty 50, Nifty Next 50 and Nifty 500 are its popular indices. So that's pretty much it about the explanation part. Let's move back to the question number 3 and let's see if we can solve it now or not. So as per statement 1, at max 49% of shareholding shall be held by shareholders who do not have the trading rights. This statement is a little tricky one, but we'll analyze it properly and reach out to a conclusion whether it is correct or not. So as we know that minimum 51% of shareholding shall be held by the shareholders who do not have the trading rights. So when this minimum 51% is being held by the shareholders who do not have the trading rights, then maximum 49% of shareholding can be held by such shareholders who do have trading rights. So this statement had been correct when it says at max 49% of shareholding shall be held by shareholders who do have trading rights. Or conversely, it could have said that at minimum 51% of shareholding shall be held by shareholders who do not have the trading rights. Hence, we get to a conclusion that statement 1 is wrong. As per statement 2, process of demutualization must be completed within a time span of 6 months, which we know is wrong because as the approval is given, this 51% of shareholding should be held by the public investors who do not have the trading rights within a time span of 12 months, not 6 months. So this statement also is a wrong one. Moving on to the statement 3, Bombay Stock Exchange got demutualized in the year 2007, which perfectly is correct because BSE got demutualized on 16th May 2007. So now we know that statement 2 and statement 1 are wrong ones and statement 3 is the correct one and we need to find out the correct one. So here option A becomes our correct option which states statement 3 only. So let's move on to our next question. Moving on to the next slide. As per question number 4, what is the maximum penalty if a recognized stock exchange or clearing corporation fails to conduct its business in line with the regulation of SEBI? Option A says 25 crore, option B says 3 times of gains made, option C says 5 times of gains made, option D says either A or B, whichever is higher, option E says either A or C, whichever is higher. So this question can be a little tricky one, so let's learn something more about this question in the explanation section. So when we delve into the details of section 23GA of Securities Contract Regulation Act 1956, this is a new section that is added which deals with the penalties for failure to conduct business by stock exchanges or clearing corporation. So as per this question, when a stock exchange or a clearing corporation fails to conduct its business, including its member or any issuer or its agent or any person associated with securities market, then they shall be liable to be penalized. And what will be the penalty? We'll learn in the next slide. So moving on to the next slide. So as per this section, the minimum penalty that is prescribed is 5 crore rupees, but it can be extended to 25 crores or 3 times the amount of gains made, whichever is higher. So the minimum bar is set at 5 crore and it can extend up to 25 crore or 3 times the gain made, whichever is higher. So let's understand how this penalty will be applicable with the help of an example. So let's say a stock exchange made a gain of rupees 10 crore. Then the minimum penalty is 5 crore, which anyways is not applicable because the gains made are very high. Now it can extend up to 25 crore or 3 times the amount of gain made, whichever is higher. So the 3 times of 10 crore would be 30 crore. So between 25 crore and 30 crore obviously is the higher one, and that will be the applicable penalty. So I hope I have made myself clear. So that's pretty much it about the explanation part. Let's move back to our question number 4 and let's see we can solve it now or not. So what is the maximum penalty with respect to stock exchange or clearing corporation failing to conduct their business in line with the regulations by SEBI? So the answer is 25 crore or 3 times of gains made. So here the correct option is D, which says either A or B, whichever is higher. It's time for us to march to our next question. So moving on to the next slide. With respect to question number 5, as per section 23F of Securities Contract Regulation Act 1956, which of the following acts are liable to be penalized? Option A says if any issuer dematerializes securities more than the issued securities of a company. Option B says if an issuer delivers securities in stock exchange which are not listed in the recognized stock exchange or such securities have no trading permissions. Option C says neither A nor B are liable to be penalized. Option D says both A and B are liable to be penalized. So let's learn something more about this question in the explanation section. So moving on to the next slide. So if we see section 23F of Securities Contract Regulation Act 1956, this section deals with the penalty for excess dematerialization or delivery of unlisted securities. So as per section 23F, if any issuer dematerializes securities more than the issued securities of the company, that is, the dematerialized securities are even more than the securities being issued by that company, or delivers in stock exchange the securities which are not listed on the recognized stock exchange, that is, any unlisted securities being delivered on a stock exchange, or delivery of securities which have no trading permissions, that is, securities whose trading permissions have been banned are being given to the stock exchange, all such acts are liable to be penalized. And what will be the penalty of such acts? Let's see in the next slide. So moving on to the next slide. Penalty for such acts shall not be less than 5 lakh rupees. So the minimum penalty is 5 lakh rupees, but it may even extend up to 25 crore rupees. So that's pretty much it about the explanation part. Let's move back to our question 5 and let's see now we can answer this question or not. So now we know that if any issuer dematerializes securities in excess of the total securities being issued by the company, that act is liable to be penalized. And if an issuer delivers unlisted securities or securities which have no trading permissions, that act also is liable to be penalized. So hence here the correct option is option D, which states both option A and B are liable to be penalized. So moving on to the next slide. In this slide I have collated all the answers. You can cross check your answers if you want to. Now a little surprise for you. Moving on to the next slide. This is an extra question for you guys, answer to which I will not be discussing in this video. I really encourage you to pause this video here, go through this question completely and type in your answers in the comment section below. Well, that's it guys for this video. If you want to know more about EduTab, please log on to www.edutab.co.in. If you have any queries, please drop them at hello@edutab.co.in. We'll be more than happy to address them. You can even contact us on the mentioned mobile number for further assistance. If you found the content of this video to be useful and informative, please don't forget to hit that like button. And for having continuous updates regarding the new videos uploaded, please subscribe to our YouTube channel and press the bell icon. Well, I hope you enjoyed this video. Thanks for watching. Happy learning. Bye-bye.